you all for coming. Thank you all for coming. So today has a single purpose, but I'm adding a second purpose. The second purpose deals with the proposed construction of new homes. There's been a meeting last night, and there will be a meeting tonight in the town. But I'd like to get the attorney to the microphone as quick as possible and allow time for you to ask questions to the attorney. I'll start off with this. Anyone who received a letter from the township about this proposed lot needs to see me at Whitman Mary before you leave, okay? And anyone who received a letter saying, why am I getting this letter? I live on the other side of the development. We need to see you too. Because there's a legality about notification to owners within 200 feet of the proposed construction area have to be notified. And if they fail to do that effectively, then this thing, we can throw a monkey wrench into it, slow it down, and hopefully get time to combat this really well. If you got a letter, let me know. And if you thought you should get a letter, I have maps out on the side on who should have gotten a letter, where I will discuss that at the end. So please find me, okay? The maps are out. I made a map this morning. I colored the lots in with a pencil. You know, we're trying to, combat this. Okay, so getting to the main purpose of today. The main purpose of today is, it is the board's responsibility to maintain transparency of anything of this magnitude that costs us money. Well, you should be transparent on everything, but I don't think you care if we spend $200 on toilet paper, okay? We've got to spend $200 on toilet paper. So the issue here is, we had a lawsuit. The lawsuit ended up costing somewhere around $95,000 to the community in legal fees. That equates to over, let's use a round number, $100 per household. So you're entitled to know why that happened. And that's the job of the board, total transparency. No, it's 100. I did the math 10 times, I know what it is. 95 divided by 926 is like $100 a year, 102. But either way, we shouldn't have had to spend that money. We should have had to, I don't know. I'll leave that up to the attorney. So I am going to stop talking, and I'm going to get Dave Merritt up here, our attorney, who will handle the entire litigation, and he will discuss points to the litigation to give you as much information as possible. This is being recorded, right, Ed? Okay, so that any resident who did not have the opportunity can view this later, and we'll have that. Okay? So, Dave Merritt.
All right, is that a good, am I getting the audio? A little louder. All right, here we go. All right, so thank you all for having me here. As Mike mentioned, I'm David Merritt. I'm with the law firm of McGovern Legal Services. We represent the association as a whole. We don't represent the board. We don't represent the individuals. We don't represent the management company. We represent the association. The reason that I'm here today is, as Mike mentioned, the association has a duty of transparency to its membership as to how the association's, the board elects to spend your money, what decisions the board implements, and your costs and where your maintenance assessments go. I also want to have an opportunity to take question and answer from the membership, so I have a lot to cover, but somebody can tell me when it's 11:40 if I'm still talking. We got to get the question and answer. More specifically, I would like to update you on the lawsuit that the association has been facing, and to give you kind of a sense of why the board approached the lawsuit the way it did, and why the board chose to settle the lawsuit the way that it settled. So the big update for the membership is that the lawsuit has been settled as of a month or two ago. The settlement involved full release of liability for the association, full release of liability for the plaintiffs, and no money changing hands. So effectively, we start anew. What happened in the past is in the past. There cannot be litigation over what happened in the past. That's the real primary benefit to the association is that we have a clean slate as far as the court is concerned. Of course, what happened happened. It's not like things didn't happen, but there can be no longer be litigation about everything that happened up until the point of the settlement. Second is that no money changed hands. So the association didn't spend any money, they gave any money to the unit owners didn't give any money to the association. So it's really both parties walking away, except for the fact that the unit owners remain unit owners in the community, and things that happen after the date of the settlement, of course, are still fair game, because you can't release claims that happen tomorrow. Something tragic happens tomorrow, of course, everybody would still have recourse to the courts. So stepping back to how this all began, the board and the association were served with a complaint. The base of the lawsuit alleged breach of the declaration, unjust enrichment, bad faith, and unfair dealing. And the demand on those claims was compensatory damages, which was effectively a refund of the $1,900 membership fee that the unit owners had paid, consequential damages, which was never really explained, and the cost of the lawsuit. Now, those were counts 1 through 3. Counts 4 and 5 alleged breach of fiduciary duty. So that was a demand against the association, as well as Mary Adler, Carol Butterworth, Michael Messina, Charlie Rock, and Edward Whitman to pay, in addition to the $1,900, punitive damages. And the document served on the trustees and on the association demanded $20,000. So ostensibly that $20,000 included the punitive damages. Now, punitive damages is a term that is meant to include the word punishment, right? Punitive means punishment. So effectively it's, we think that you owe $1,900. In addition, we think that your conduct was so egregious that you should have to pay $20,000 total as punishment for what you did. And that was not just to the association, that was, as I said, to Mary Adler, Carol Butterworth, Michael Messina, Charlie Rott, and Edward Whitman together should have to pay that $20,000. The last count of the complaint was that Mary Adler, Carol Butterworth, Michael Messina, Charlie Rott, and Edward Whitman should personally have to refund the association for every membership fee that had been refunded to people that had moved within the community. So whenever somebody moved from one home in the community to another in the community, we have evidence going back to 2013 that the board had this, at that time, unwritten policy that you got your membership fee refunded, because although you briefly owned 2 units in the association, or may have moved out briefly and then moved back in, you effectively were staying a member of the association throughout, so the board historically had approved refund of that membership fee. And the demand was that those 5 trustees that happened to be on the board at that time should have to refund the association for all the membership fees that had been excused in the past. So the board was faced with that complaint. On top of that complaint came a demand for each of their tax refunds, tax returns. So they wanted to know from 2020 to 2025, what did Ed Whitman declare on his tax return? Because we want to understand his assets to understand how much the punitive damages we should be. Because part of setting punitive damages is how much money does Edward Whitman have, or Michael Messina have, or Mary Adler, or Carol Butterworth have, because we want to set those punishments to actually impact them and be calibrated to correct their conduct based on their assets. So somebody with millions of dollars ostensibly gets a bigger punishment than somebody with very little money. So the board received all of this, and it was impossible to interpret this lawsuit without looking at the context of the prior disputes between the unit owners and the association. So these particular unit owners have a long history of very vocally challenging board decisions, disputes arising out of realtors' forms, allegations of misconduct by other realtors that list homes in the community, allegations of misconduct during home sales and how those unit owners' clients were being handled in home sales, violations of civil rights, lack of transparency, breach of fiduciary duty, legality as to switching the gate guard to an electronic gate guard, and whether that's illegal or a breach of governing documents, all of these different things. So there's a large number, the reasonable accommodation granted to the Jewish community to use the gate code at the side of the property. Yeah, so a lot of these things were topics of dispute with these unit owners. And more than the substance of the dispute, because of course all of you probably have opinions about a lot of these topics, more than the substance of these disputes was the method of the disputes. So as a course of conduct, typically, a lot of these disputes got reduced to attorney letters on attorney letterhead. So the association was getting hit with a lot of these letters from the unit owners' attorneys saying that we dispute this, we didn't dispute that. And of course, as an attorney, my concern is how are these things being presented to the association? So more specifically, putting things in writing as a consequence as opposed to raising them verbally at an open board meeting, right? It's a lot easier to have open and free discussion when we're talking verbally at a board meeting, when we're conducting Q&A. Putting them in writing has consequences, right? If you put a threat to sue the association in writing, that has consequences for your insurance policy. Additionally, if you put a communication on attorney letterhead, you have the right to legal representation, right? Everybody has the right to have their attorney, but that has consequences. When you get a letter from the board on association letterhead versus getting a letter from me on legal letterhead, it's gonna impact you differently. You know, even if it says exactly the same thing, it says, you know, please clean up your flower bed, the fact that the association paid me to write that on legal letterhead is gonna land differently with you as a unit owner. It's the same thing for the association. When the association gets a demand from a unit owner in an open board meeting that's verbal, you know, we can have a discussion, you can talk about it, and we can resolve it. When you get a demand on attorney letterhead, it's gonna be interpreted differently. So 2024, we have letter from attorney for the unit owners about the realtor forms. No right to demand information from prospective buyers, particularly even before they have a firm contract. My client considers these repeated emails to constitute harassment. Moreover, they may also constitute tortious interference with prospective economic advantage or with contract. Cease and desist from sending emails to her clients demanding that she provide forms of contract purchases or take any other action regarding real estate contracts. Unit owners reserve all rights to seek further relief. So that's having to do with forms that we're seeking to get the age verification for people that are looking to buy into the community, because the association has an obligation to track aged people that move into the community. 2023, we have an attorney letter on attorney letterhead requesting that the association and the board pursue violations against 9 units that are listed. Unit owners report that they are aware of at least 9 units where the owners have installed and maintained river rocks and stones in their planting beds, and demanding that the association pursue those and demand that the unit owners remove those river rocks from their planting beds. Compel the offending lot owners to return their planting beds to the allowed materials. 2025, we have a letter, not to the association, but to one of your ordinary unit owners, a member of the association that spoke to the unit owners at an open board meeting. You approached her and verbally accosted her, demanding to know what she was doing at the meeting. Cease and desist from approaching her and from communicating with her. All further incidents may result in legal action. 2025 to Ed Whitman. Mr. Whitman stormed up to the unit owner, and I'm paraphrasing, stormed up to the unit owner and thrust his face into hers in a harassing and intimidating manner, exclaiming hello. Refrain from actions intended to harass or intimidate her. Okay, so putting these as I said, unit owners have a right to speak, and we all have the right to free speech as Americans. But using these words, harassment, intimidation, reserve all rights to pursue legal action, they have consequences. Harassment in particular, harassment is not a civil cause of action in New Jersey. Harassment is a municipal court criminal violation, it's a misdemeanor violation. So these words have consequences. The attorney letters are very specifically phrased to avoid any defamation or anything like that. But they are received by the association in a certain way, and they have consequences. Right. Now, I've talked in the past about how the association resolves disputes, and principally, we want associations, we represent more than 400 associations across the state. We want associations to resolve disputes politically. and the state wants the associations to resolve disputes politically. They want people to elect your representatives. So if you don't like a decision of this board, and you want this board to revisit that decision or change that decision, the state wants you to run or elect somebody who's going to make a change of decision on that. So the association is a representative democracy. You don't vote. With a few exceptions, the members don't vote on everything that happens. You vote to elect people to make those decisions for you. And if you don't like the decisions, you can always toss those people out. Right? You can petition to remove the board, or more importantly, you can run yourself and get on the board and reverse any of those decisions. So that's what the state wants, right? The state is focused on how do we make sure that elections happen fairly? How do we make sure that the membership has a voice through this political process of voting? And that happens whether or not lawyers are involved, right? You have regulations, you have your governing documents about how elections happen, and you have that expense. So let's address these disputes through the process that we're already paying for, which is to have these fair and transparent elections. When you approach disputes legally through the law, right? When the association gets a letter from an attorney on attorney letterhead, the association is, among other things, a corporation. It's a democracy, but it's also a corporation. The board can't respond to that, right? You have to have your lawyer respond to that. When you get threats from a lawyer, you have to send them to your lawyer, especially for an entity like a corporation. So there's a cost, right? Lawyers don't work for free, as Mike mentioned. Lawyers have a cost. And even if you're not in a lawsuit, that's going to be a cost on the association and a burden on the association. So anytime you're resulting to this legal process to address your disputes, that adds a cost on top of the normal expense to run the association. And that cost is principally attorney's fees, because even when you're not in a lawsuit, you're paying a lawyer to look at these letters and advise the board on the proper response to the letter and write a response to the letter. But it's also a burden on the board and on management, because they're not able to focus attention on snow plowing or landscaping or these core association duties, because they're having to take time and energy away from that. And principally, I've been told that disputes like the ones that we're talking about have led to a number of resignations from your board and from your site, from former presidents and property managers, just because of the toll of having to deal with these kinds of side issues and disputes that are outside of kind of the core running of the association. And that's also a cost to the association, that you're draining the time and energy of the volunteers that want to be on the board. A lot of people end up on the board because they have a single issue. They're really into the trees. They want to make sure the trees are done well, or the lawns. And then they get on the board and they realize how much time it takes and how much dedication you have to put into every other issue. And when you're adding on these disputes, that's a tax on the association, and it's a cost on the association. So addressing things through this legal process, while unit owners have that right, everybody has a right, same as the right to speak, you have the right to access to the courts and to hire your own attorneys, it does add a cost on the association to pursue your disputes that way. Now, this board understood that. The board that was sued understood that. They came into, they were elected to the association in May 2023. That was the time, that was when Mike first became president, and the trustees that were sued came onto the board. They looked at the prior history of the disputes, and they asked to meet with the unit owners. Now, I don't want to get into the who said what at that meeting. Part of having these meetings is we want people to be able to meet with the board and talk freely and not have to worry about the repercussions of what they say in those meetings. So I'm going to be very specific. I also think that you need to have an understanding of the demands that are placed on the association, because ultimately those are demands being made against your maintenance assessment. So I'm going to be very specific here. The board met with the unit owners at that time. The topic of that meeting was a demand to address prior mistreatment by Alan Maines, Richard Weiland, and Bella, and I'm not going to be able to pronounce what that's name, for violating civil rights, silencing Q&A, lack of transparency, the failure to fulfill fiduciary duties, as well as the attorney's fees that the unit owner had incurred up to that point in things like these legal letters in relation to those demands. So it was unit owners having accrued a significant amount of attorney's fees for what they perceived as dealing with misconduct by Alan Means, Richard Weiland, and Bella, and wanted reimbursement of that. They wanted reimbursement of their attorney's fees accrued in those matters. Now, anytime the board gets a demand for money from a unit owner or from anybody else, somebody that might have had a slip and fall on the street outside, or an employee, or employee of a contractor, the association always has to think, the board always has to think about, okay, well, is this a valid demand, but also how much are we going to spend on attorneys or on insurance to defend this, right? Because whether or not you're paying my law firm to defend a case, or you're sending it to an insurance carrier, you're going to be paying for that one way or another, because anything put into insurance companies don't lose money. They adjust your premiums, or they cancel your policy, and they get it back from you. It's just amortized over a period of time. So the board is always having to think about, well, how much are they asking for, and how much is it going to cost us to litigate this out? Now, we're talking many tens of thousands of dollars. You've seen an example here of how much it costs in 2025 to litigate a lawsuit to conclusion. And the board always has to balance, well, I want $1,900, and implicitly the board knows if we get sued over this, even if we win, we're going to have to spend a significant amount of money. So the board has to balance that, and anytime that demand is made, there's always that implicit threat that even if we're not going to end up being liable for their attorney's fees, the association is going to be spending a bunch of attorney's fees defending the case. I think the board, seeing this complaint in this context with the long history of prior disputes, decided that we needed to say enough is enough. We are going to litigate this to conclusion. We're not just going to spend the $1,900 to make this go away. There's a very good reason for why we refunded the $1,900 to the people that moved within the community, why that's different from somebody who purchases 2 units within the community and sits on the second unit. And if we keep up this process, we're basically just allowing one unit owner to put their finger on the scale of association decision-making on a broad variety of topics, whether it's realtors forums, or how closings happen, or gate guards, or anything like that. And that should be a political process. That should be the membership electing who we want. And it should not be the board cowed into, well, we better do this, otherwise we're going to get sued. So the board decided to defend the lawsuit in normal course and to litigate to conclusion and have the court render a decision. I presented previously, just very briefly, we were in court, and really the lawsuit came to a head in October, I believe. We were very lucky. We had Judge Ducey, who was a former mayor for I think 10 years in Brick, brought his perspective to the lawsuit, looked at it and said, of course the board had discretion to make this decision, to say, these unit owners over here, when they move within the community, it makes total sense that they get a refund of their membership fee. These unit owners over here are in a different category. They bought and are sitting on their second home. That's not the same thing. Not only does the board have discretion, but from the way he presented it in court, I think he supported the board's decision on distinguishing between those two categories. So the judge heard that, decided the court issues. There were 2 counts that kind of were still open, that because of the technicalities of the lawsuit, it would still be court Judge Ducey on those 2 counts. But his ruling effectively addressed the entire lawsuit. Basically said the association is right, the board is right. They have the authority to do this. There's no liability here. The plaintiffs signaled their intent to appeal, right? So in New Jersey, you get an automatic right to appeal to the appellate division, to have the appellate division look at Judge Ducey's decision and say, was he right, was he wrong? And what's our opinion? And we're gonna substitute our judgment for Judge Ducey's, or we're going to say, you know what, we agree with Judge Ducey, we affirm. Beyond that, you also have the right to petition in the Supreme Court. The Supreme Court doesn't have to take every case, but you can go petition the Supreme Court and ask the Supreme Court if they want to take the case. And that, of course, is a lot of additional expense, right? We talked about how much the association spent up till now. The intent to appeal is basically just saying, we're going to incur a bunch more attorney's fees on this. Case kicked around a little bit, kind of applying to the court to reconsider. Judge Ducey did not want to reconsider. Ultimately, the offer was made to basically have a clean wipe, no money changing hands, both parties walk away, and that settlement went through. Right? So we were able to end the case with that resolution, consistent with Judge Ducey's rulings, and in addition, to have an agreement that we're going to wipe liability clean through the date of the settlement. So both parties get the assurance that nothing in the past is going to become the basis for a new lawsuit moving forward. Now, I recognize that among the membership, there are those that feel that we should have just paid the $1,900 to begin with and avoided the attorney's fees. There are those that felt that we should have litigated this to the end and attempted to get the association's attorney's fees back from the unit owners. Now, there's a lot more instances where unit owners are able to seek to recoup their attorney's fees from the association than the association from the unit owners. So a great example of that is civil rights actions. If a unit owner alleges that something's being done to them because they're a protected class, right, they're of a certain race or religion or orientation, that comes with fee shifting, right? You as unit owners have that right. The state feels that those interests are so important that if you're successful in those cases, you should get your attorney's fees back. The association doesn't have those same kind of things, right? The association doesn't have civil rights the same ways that you have civil rights as unit owners. There's a few instances where the association has the right to recoup attorney's fees. There are things like intentional violations, right? You commit a crime against the association. There are things, the most important one is when you have a contract that says that the association has the right to recoup its attorney's fees. And the easiest example of that is if you don't pay your maintenance assessments and the association has to pursue you to recoup those maintenance assessments, then you also pay the association's attorney's fees. That's a contract right. It's because it's written into your declaration, which is a contract between the association and the unit owners. The association can then recoup its attorney's fees and costs in that context. When this suit began, you didn't have that in your contract. So the only basis that there would be for seeking attorney's fees from the unit owners are these really kind of esoteric causes of action that have to do with intentional misconduct and intent to harm the association. And those are a breach. Those are very tough to prove. I talked a little bit about them, but they're not cases, they're not causes of action that we as a law firm bring, but they're out there. So they exist, and it's something that the board potentially could have pursued after this lawsuit was over. So the decision was made, you know what, we're not going to pursue that. We're going to take this clean slate. So I understand some people really wanted to pursue those claims, but the decision was made. We're just going to walk away. Everybody's going to have start over on this. So settlement terms, the last piece of this puzzle for us as a law firm is, right, we wanted to wrap up this lawsuit, but we also wanted to put something in place that would prevent this from happening again in the future, or at least minimize the chances that this happens again in the future. And as I said, one of the ways that you have the right to recoup your attorney's fees is by contract. So we approached this with a two-pronged approach. When the board said that they wanted to draw a line on this and litigate it to conclusion, we said, okay, well, let's litigate the case to conclusion, but let's also amend your contracts to address this issue in the contracts. So the membership, by your board vote and membership vote, amended your bylaws, I believe in November. Those were recently recorded. The new bylaws are effective now. And they did a variety of things, so it wasn't just about this particular instance. But the big change for this is that the governing documents were amended to provide for litigation costs in the event of any litigation between the association and any lot owners or lot owner's guest, tenant, or any other resident residing in any lot owner's lot, whether or not the action is brought by the association shall be entitled to recover all court costs and attorney's fees incurred in prosecuting or defending the action as applicable from the lot owner. Okay, so as I mentioned, approaching things through the law, through a legal perspective, places a cost on the association, right? The association has to spend the money to defend itself. The association has to spend the money to get competent legal advice from its attorneys. There's two ways that the association gets money, two principal ways. You get a little bit of money from the town, from other sources, but two principal ways that you get money. First is you divide it up equally among everybody, right? That's how you were operating. Defense costs for the association, you took those costs, you divided by 926, and you all pay $100 to defend that lawsuit. The other way that the association recoups money is to assess it to the specific unit that caused the expense. That is not a moral judgment. It's not a they were negligent. It's not a they did something in particular wrong. It's just that unit owner caused the association to have an expense, so they should bear the cost of that expense. Sometimes you'll see it in condos where they say, we're going to come and we're going to provide a service for you. We'll clean your dryer vent, but we're going to charge it back at cost. You had the benefit of cleaning your dryer vent. You're going to reimburse the association for that. So that's the other way that the association gets money. And what this is doing is basically saying, we're going to treat lawsuits that the association gets pulled into not as a general expense to go to every unit owner, but as a specific expense to be charged back to the unit owner that incurs that expense, whether it's by the unit owner or their tenant or their guest. Now, the court is always going to have the right to interpret those documents and to impose its own judgment on what is reasonable in those cases. Right? The courts in New Jersey are generally like to second guess and reconsider association decisions and impose a reasonableness standard. So it's not an unlimited power. There's always going to be the court saying, those attorney's fees were too much. They need to be written down. This should go to the general membership. This should go to the unit owner. But what's going to happen moving forward is when unit owners sue the association, typically at the end of that lawsuit, you're going to have your attorney's fees to the association. The association will pay those fees as they go, right? We don't work on contingency. We are paid as we go. But at the end of those lawsuits, those attorney's fees would become an assessment on the unit. There would be an invoice to that unit owner. The attorney's fees invoices would be attached saying the association has spent this money. Per the bylaws, those fees are now going to be assessed back to your unit because they arose from issues from your unit or that you raised with the association. Rather than spreading them among the membership, they're going to be charged to your unit. They'll become an assessment on the unit. And if it's not paid, it will go into collection, same as any other maintenance assessment. So typically you would, if it's not paid, you would record a lien for those amounts and leave that lien on the unit to be paid when the unit goes to sale. So that's the two-pronged approach of how we address this is first, let's litigate this out, at least until we get a decision from the courts and a binding resolution via this settlement that addresses the claim and all other claims that happened up to that point. Second, let's update your contracts or governing documents to help make sure that the expense of future disputes like this are not spread as much around the community as a whole, but are instead put on the unit owner or unit owners that incur the expense. So that's what we did, and I think I covered everything. So that's where we're at. That's why the association chose to spend the $900,000 to defend the lawsuit, and why the association chose to settle the lawsuit with no money changing hands and with the general release.
Okay, so we're going to start a Q&A to the lawyer. Anyone who wants to, please utilize both sides, and we will alternate. Sue got our first, so Sue, state your name and your address.
Before we get to Q&A, I do want to remind the membership that this is recorded for the benefit of everybody to have a clear record of what happened, and for the members that are not here. You've heard examples of legal letters sent on the basis of what people have said at membership meetings. While the association now has this ability to charge assessments back for its attorney's fees, obviously that does not extend to the individual unit owners. So please take care, as I said, everybody should take care in what they say and how they speak, because we want to make sure we're not generating more new disputes and causes of action.
Okay, we're going to start on this side with Sue. State your name and address, please.
Yes, Susan Agreska, 2846 Roseville Court.
You have the floor.
Thank you. I have three quick questions. Number one, now that the owner did not appeal the decision, does that mean that even all the other past people that were written in a law paper is now okay, like they don't have to worry anymore?
So the release is a release to the association and its agents and officers. So for prior trustees, for causes of action that have to do with anything that they did as a trustee, it would be effective for them. So I think we talked about Alan
What about
Reeves, Richard
residents?
Bartlett, and Bella. It would release them as for the conduct of trustees. I can't do something that impacts every, I don't represent the general membership. So as individuals, no. It is not a release of liability for any disputes that you may happen to have with the unit owners over something unrelated to the association. It's a release for the association and its agents and officers. So primarily, that's the people who have been on the board now and in the past for things that they did as volunteers on the board.
Okay, second question. If, you're talking about the trip and the fall, I know I just wanted to mention that because we lost our insurance. Is that something that as soon as somebody falls and sues, just even with any kind of letter, does that automatically go to the insurance company?
So you do have some protection in place. You have tort immunity for when a unit owner injures themselves. They can't recover for ordinary negligence. But to your question is basically yes, anytime that we receive notice of somebody being injured on the property, anytime that somebody demands something from the association and implicitly or explicitly threatens to sue the association has an obligation to put its insurance carrier on notice of that. Because the insurance carrier, right, they have to do all the math to figure out what are the risks involved in insuring this property. I'm going to take the responsibility for anybody that's injured in the clubhouse. I need to understand to budget properly to be able to cover those costs. I need to know, and my insurer has to be honest with me about that. So if you don't report those things, it can lead to a loss of coverage. If you don't report the first instance where you knew of the injury or where the demand was made, then the carrier can say, sorry, you didn't tell me about that, and I renewed your policy at the existing premiums when you were hiding from me the fact that you had these liabilities out there. So I'm not going to cover those liabilities, or I may cancel your policy. We do have to balance that because every time you put a claim in,
Any claim?
it goes, even if they never file a lawsuit, they never pursue anything, it's still a claim on your claims history. And that goes into the math in some nebulous way that I'm never going to understand to set your premiums, or for the carrier to say, you know what, I wrote your policy last year, but I think it's time we stop doing business. I'm not going to renew. Go find another carrier next year.
Okay, and my other question is, I know that we revoked the bylaws, and the 1900 is still something that can be reimbursed. I was kind of hoping that wouldn't happen, just so this would be something that would never happen again. Is there a reason why we're still going to reimburse, or what is the, why is it still in the bylaws that we can do that?
So that's more just a political decision for the board, that they felt that these instances where members move within the community, and the members voting to enact this, all the members that move within the community should be reimbursed that. With Judge Ducey's decision, and with the new language we put into there, there's really no basis to challenge that refund moving forward. There is more explicit recognition of the board's discretion to say, okay, here's the instances where people you've elected to make these decisions think it's fair. It wouldn't be fair to refund it in that case. We're not refunding it to you. So it does give the board, the people that you elect, power to make those decisions on a case-by-case basis, ask for more information, and be protected from the decisions that they make on that. But yes, the membership fee refund still exists. We want people to know about it. I think part of the unit owner's problem with the membership fee was it wasn't really broadcast for the membership, so not a lot of people knew about it, but people were using it without everybody knowing about it, and you couldn't use it if you didn't know about it. So now it's written into the documents. It wasn't a resolution, now it's in the bylaws. So if you do move within the community, please be aware that you are entitled to apply for and obtain that refund.
Okay, thank you very much.
All right, we're going to go this side. Brian, state your name and
Brian from Logan Court. Hypotheticals of the person involved here, I know does conduct business in our community. Being with all these things that she's been suing us, I know it might bring on more problems, but is there any way to limit our business practices in our community?
So when you select a realtor, that's a decision between the unit owner and realtor, the association really is not going to get
If that's what
involved.
she does, and she does sell houses in the community, so that's why I'm asking, is there any way we can limit our business practices in our community? I don't know what they wanna do that, but at least some sort of punishment.
Yeah, we, the association and the board, the answer to that is no, right? You know, I have read to you, right, that mentioned tortious interference with contract. That's a cause of action in New Jersey. We're not going to interfere in people's ability to choose their realtor or their relationship between the unit owner and their realtor when they want to go list a house. But I don't represent you as unit owners, and you get to make part of this whole idea is you get to choose the realtor that you want. So pick the realtor you want.
We'll go to the side, name and address, please. Maria.
Maria Lee, 2555 Brenton Lane.
You
Two
have- You have the
questions.
floor.
Is this settlement considered collateral estoppel? Is that what it would be considered?
Yes, you know, it's so collateral estoppel is if you sue somebody and you litigate that to conclusion and you don't have a settlement,
Right.
you're stopped from pursuing other claims. That's an implicit release of those other claims. It's entire controversy doctrine is another word for that kind of concept. This is just a explicit. Everything up till the date of the settlement is released. No
Okay.
lawsuits, no liability, everything
Right.
up to the date of the settlement.
Okay. Second question, and I don't know if you as the lawyer can answer it or Mike needs to answer it, someone from the board. There is a statement that's been published. We have a Facebook page for the community, and I don't know if it's a true statement or a rumor that's been going around that this whole situation is unfair to the homeowner because this has happened 7 times before, very specific, 7 times, and it has been settled differently. My understanding is that when a homeowner purchases another home, already lives in the community, but decides to purchase a second home and then sells the first one, this has happened before, and it's been handled in the appropriate fashion. So can someone put to rest that rumor or statement, whether that's fact or fiction?
So I haven't read the statement, so I'm going to be guessing about what specifically she was referencing. My record showed that it might have added up to 7 by the end, but as of December 2018 till now, there were 4 instances where the membership fee had been excused and refunded, not excused, but refunded. I think it seems correct that there would be 3, if you go back to 2013, which is the earliest that we know of this refund happening. So I'm gonna guess that we're talking about instances where the membership fee was refunded to the unit owners, and all of those really predated the resolution that was passed, so they were just kind of the board making decisions unofficially. In each of those instances, it was where somebody moved from one unit in the association to another unit in the association. Sometimes they owned 2 at once, and there was an overlap. Sometimes that overlap became extended because a lot of times people do renovations or things like that, and contractors never happen as fast as you think they're going to happen, things like that. Another instance was somebody moved out of the community for like a month and then realized that they really missed it and moved back into the community. So there wasn't an overlap, in fact there was a gap between the 2. But in each instance it was an existing established unit owner who already understood the way the community works and how the community operates, moving within the community. The unit owners, the applicants here, purchased 2 units,
Yes.
are still own the second unit, and have refused to give any explanation for what they want to do with that second unit. So I don't know their purpose in owning the second unit. If it's eventually sold, if they move and into that second unit and then sell their first one, and there's only ever one person living, you know, the same residence, both units, that's something that the board can consider. But as of right now, I don't know if they're going to lease out that unit in the future,
Right.
or if they're just sitting on it for investment purposes. So without understanding that, I think the board had to say, we had this refund, and the intent of this refund was for people that moved in the community when we didn't have additional occupants moving in. We can't get an answer as to, are there going to be tenants? Are your, age qualified family gonna move into that unit as your guests or your licensees. And so that was the distinction between this, I guess, 7 that moved and the plaintiffs as unit owners, and why the board decided initially, as it was presented, there was no resolution in place explaining this. The board just had a history of what had happened, and the board received the application from the unit owners to say refund my $1,900, and they came and talked to us because of course lawyers were involved, and we said, to the extent that this exemption hasn't been explained, they're right. We need to tell people that this exists, and we need to try and explain the scope of this refund. So you didn't have that in place for those prior decisions, but that was an intent to explain to the owners as a whole why that was happening. And part of that was the board coming to grips with, okay, well now that we're having to define this refund, why these 7 people got this refund, should this other unit owner get it as well? Is it appropriate? And the board decided no, and that's what you elected them to decide.
Thank you. I want to be able to refute if it's a rumor, and I want to be able to do it truthfully based on the information that you've just given me. So I
It sounds plausible
appreciate
that from 2013 till now, there were 7 refunds, 7 times that this was refunded
Right.
to unit owners.
But to clarify, not the same situation. That was what I was
Right, and that
trying
was-
to get clarification.
Right, and that was the judge's ruling.
Okay.
So, public record, you can get the transcript, you can read Judge Ducey's ruling,
Okay.
and that was his opinion, was not the same situation. It's
Right.
not on the board, but the judge.
Thank you.
We're gonna alternate, and we'll be on this side. State your name and address, please.
Louise McInerney, 2373 Woodbine Lane.
Louise, you have the floor.
Thank you. First of all, thank you for taking care to explain it in a nice, slow manner, this whole episode. We appreciate your care for us. The thing is that we have just spent $95,000, and the original offering that all we had to pay was $1,900 for that May meeting, and maybe 20,000 more. So it would have only come to $21,000 that we would have had to pay. So there's a big upsetment as to how this was first presented, and the rumors are rampant. Well, why didn't Mike just pay the $1,900? Why didn't he just pay the $2,100? That's the rumor, Ed. And we've got to go back to the beginning, that May meeting, when it was presented to them, what was asked at that May 2023 meeting.
So that meeting was about prior disputes. So they had not purchased their second home at that time. That was about alleged misconduct by Alan Means and Rich Weiler
Oh,
and
okay.
Bella. But that goes to illustrate, there's always another demand, right? There's your big community, you're always gonna have unit owners that are asking for money from the association. Whether it's these unit owners or other unit owners, people are always gonna be saying, I deserve to be treated differently from everybody else, here's why. And sometimes the board is gonna say, you know what, we actually understand that. You deserve to be treated differently because you move within the community and you should get a refund of your fee. And the board will refund that and you can all move on. But at some point, the board has to say, no, we can't keep giving money back to the people that complain, okay? A lot of people in the community live in the community and never demand money from the association and never demand rights from the association. And they just kind of live quietly, and that's great. And that's what I picture when I think of who I'm representing, when I represent the association, the people that don't come and I don't hear from it. What am I doing to protect them? And giving money to the people that are complaining about things can help deal with those complaints. But at some point, most boards decide, okay, but that's a bridge too far. We have to stop. And settling this lawsuit would not address the next lawsuit, and the next lawsuit, and the next lawsuit. So that was the decision that the board made, was to,
That meeting that was held in May,
Yeah.
the house was purchased 8 months later.
Okay, so then.
Very important fact.
Yeah.
That first meeting happened in May. Actually, it was June. It was 3 weeks after the new board came in and I was elected president. The house wasn't purchased for 8 months after that date. Had nothing to do with the $1,900. That house was not purchased.
So, that meeting was not about the membership fee, but from the board's perspective, the lawsuit over the membership fee had to do with all of these other demands and disputes, and whether the board was going to continue, begin or continue, basically just conceding to those demands, and the board was going to say, no, we've been elected to make these decisions, and you're going to respect our right to make those decisions.
Okay, to set things clearly then, 8 months later or 10 months later, when the unit holder came to the board asking for their money back, was that all that she asked for, was the $1,900?
Yes, at that time when she asked for the refund, it was the $1,900
Okay, and then when did she ask for the additional $20,000?
in the lawsuit.
Not before the lawsuit?
Not that I'm aware of.
Okay, all right. I just wanted to set that clear because everyone's up in arms about why we didn't pay her and, and get rid of it.
As I said, there's different feelings among the community. So some people feel that it should have been paid and should have just gone away. And some people feel that the association should have fought it and continued fighting it past the settlement. That we shouldn't have taken the settlement and we should have sought to recoup the association's attorney's fees. That's why you elect your trustees. That's how I want you to make those decisions in future, is who you vote for. If you don't feel that this board made the appropriate decision, you can be on the board, you can make a different decision next time. But the overarching point of all of this is, please participate through running for the board, through voting for the board. If you don't like that decision, then by all means, I think a lot of these trustees would say, if you'd like to be on this board, we're not going to take it personally, and you can make a different decision in the future. So we do have some other questions, so I want to.
I think that the answer to people who make that complaint would be that the judge sided with our board, that the judge ruled legally that our board made the right decision. So anyone who complains about what the board did can just say the judge agreed. Thank you.
Thank you.
At my own peril here, speaking on this issue, I can simply say that the board did not have the authority to write a check for $1,900. What would the explanation mentally be for spending close to $2,000 of your money? We had no authority to issue such a check. The plaintiff did not fall under the policy. The policy governed people who bought one house and sold the other and moved from the first to the second. This was never the case in this particular lawsuit.
So Adam, I'm going to qualify that. The board didn't have a reason for refunding the fee that way. So the point of the lawsuit was that the board did have authority to make these discretionary decisions. So I'm going to have to disagree with you on that. But the board did not have a basis for making it. The people you elected did not feel it was appropriate to refund it on that basis. And a lot of that can be, there are arbitrary demands for refunds. I understand the basis for this owner's demand for the refund. I don't think it fell within what the board conceived, but you will get truly arbitrary, frivolous demands in the future. And the board's got to make those calls about this makes no sense. But the board does have discretion to settle cases and really when there's a demand that's a litigation demand, the board has to make that call of are we going to settle this or not. But we have to explain that decision to you after that and be accountable for it.
State your name.
Barbara Wills, 2839 Danbury Lane.
Barb, you have the floor.
Okay. When I do a listing here in Lake Ridge now, there's a section on our listing agreement that asks are there any assessments? What do we put down? Because every realtor who's going to list in here has to know this. How much it is it yearly?
And it's gonna be a problem when the buyers come to, what's all this about, you know, and we have to put this
We
down.
did not do an assessment. We just did it on to the,
Okay. So, I understand you were able to work with your budget and amend your budget. There was no special assessment imposed because of this lawsuit. There's no lawsuit anymore, so you don't have to reference the lawsuit on the disclosure.
What's the $102 we have to pay extra every year?
That's just how much, if you take the total cost of the litigation.
No, I know what that is, but the people, if they sell their house, that gets passed on to the new owner.
No.
Well, it's just a one-time $102.
No, so that's just purely, the association spent this much money. I think we're adding in costs prior to the lawsuit as well. But we spent this much money dealing with this situation as a whole. Well, you know, a year and 14 months of litigation.
So it became normal operational expenses, I'm looking at Steve on the budget, and it did not go down as an assessment, but in relative terms, I said we each paid $100 on our regular HOA fees. There was a thought process about doing an assessment, but after the board looked at that, they said it would not be in the best interest of the community to list it as an assessment, so you didn't have to.
Yes, thank you.
Okay. And Steve is gonna do a follow-up on
I
that.
mean, I think you were just trying to make an example, how you decided to assess 926 homeowners would have been about $100 per person, but we didn't do that. There's no assessment. It was absorbed by the budget last year, and it's done. It's over from a financial perspective.
Right. I mean, we're talking costs that the association incurred over 2 years, and you paid them over those 2 years. We're not talking about $100,000 was billed to you yesterday. We're saying over the past 2 years, you've had invoices from our office and from the courts and other places that you paid as they came in. So in theory, $10 from, or $8 from your regular maintenance assessments that you paid for the past year and a half went towards that $100 a unit. We don't need to now go assess anybody for that because it came out of your regular maintenance assessments. And the board adjusted your budget moving forward to count that.
Okay, before we go to Carl, you're next. Remember that you need to see the board if you think you're impacted by this proposed construction, but Carl, name and address please.
I think it's a little afternoon, so I just ask if anybody else has any questions, please come up now. Otherwise, we're going to end on this as the last question.
Okay, you have the floor.
Yeah.
Say your name, Carl.
Carl Greco,
You have the floor, Carl.
2647 Meadow Lake Drive. My thing, I'm really glad that this thing is like, we're done. Okay, stop, no more, and that's good news. I did have a question, because I'm not, and I would like your clarification as a lawyer on this. It sounds like it was possible, although it was completely unexpected, to read our bylaws in such a way that somebody could make a challenge like this. Completely unexpected, I think, to anyone in this community. So that sounded to me like the bylaws themselves, as has already happened now, due to the changes spearheaded by our committee, they've made the adjustments, they've clarified the language to make it airtight, at least for this kind of situation, so that you just can't even conceive of something like this happening, all right? Because the language is not clear. It's per property, it's not per owner, if I understand it. So in other words, if that was recognized early on, and the board had discretion to pay $1,900. I'm not saying this is easy. I know you guys are working on all this stuff. It's a big deal. But it sounds to me like that would have like settled this thing way back when. And do we have a situation now with the bylaw changes that this kind of situation, or somebody's perceiving they have a legal basis to make a challenge, that can't happen in the future? And would it have been within the board's prerogative to say, okay, we're going to pay the $1,900, we don't like this, but you know what, we have these bylaws, there was a way, we didn't expect it, but there was a way to read these things that some resident could bring the kind of suit
So
that
I-
we have.
The answer generally to your question is yes. The association, not the board, but the association, the board could have said, we're gonna settle this case, and then we're gonna put to the membership, update our documents to close these. As the judge decided, there wasn't a hole, but there was enough of a doubt as to it to be the basis of a lawsuit. Now, the problem with that is, first, New Jersey courts are always revisiting things. And I can't write documents that are gonna say you're never gonna get sued again. Because anytime a case goes in front of a judge in New Jersey, judge isn't gonna, especially in a case where there's an attorney on the other side, on the owner's side, the judge is gonna say, well, there must be some merit, otherwise this attorney, in this case, a very sophisticated, experienced attorney, signed off on this and found a cause of action. So you're always fighting that bit of assumption that there must be, there's smoke, so there must be fire. So we're gonna assume that maybe there's something here that needs to be settled. So I can't write litigation-proof governing documents. But you're right, the association could have settled this lawsuit and done the amendment. The bigger problem with that for me is, politically speaking, this amendment is, I have not seen governing documents that provide this level of protection to the association. It's really above the norm in terms of insulating the community as a whole from the expense of litigation. It was written that way on purpose to try and give you the maximum protections, as you said. But amendments like that get voted down a lot. Okay, if the membership and the membership ultimately make that amendment, if we were to settle that case and then put that amendment in front of the membership, my assumption would be the membership would say, no, we're not putting that in place. We want to preserve the right to sue the association. We want to preserve our rights as unit owners. So anytime you're talking about amending the documents, you have to also consider the political realities of, is this something that's actually going to pass? And this amendment passed because of what happened with this lawsuit. I don't think that this amendment would have passed if this lawsuit had never occurred. I think the membership would have voted that amendment down, and you would have remained exposed. But I don't know, because it didn't happen. Ultimately, the board, the people you elected, chose to pursue it this way, and that's why you elected them. And again, if you don't like how they chose to do it, there are going to be seats on the board, and there's opportunity to have a different say, or to elect somebody else and have a different say.
I'd just like to add one thing. The old bylaws and the new bylaws state, the old ones in particular, each lot owner will pay. Look it up. Each lot owner will pay. Does it say if you own two, you're going to pay it twice? No, it says each lot owner. It's understood if you own two lots, you're going to pay. And that was, oh no, that's confusing. It's not that confusing, and the judge did not feel it was that confusing. Each lot owner will pay. End of story. That's all I have to say about that.
Last question.
Bill Bauman, 2873 Lennox. Lake Ridge agreed to self-insure this lawsuit, correct?
Effectively, by not putting it into the
Insurance.
So, well,
So,
I will, the insurance policy that we might have covered would be the D&O, which only covers defense costs. So you never had insurance that would have covered the liability. Policies don't cover the liability. The association is always going to be liable. If you want to talk about self-insurance, self-insurance means you choose to forego the benefit of insurance and use your own money. You never had insurance that would have covered the liability of any judgment. You might, and I didn't look at the terms of policy, you might have had a policy that would cover defense costs, but they will also appoint their attorney and litigate it kind of the way that they want to litigate it.
Are there any state regulations when an HOA self-insures in the state of New Jersey?
No.
No.
The association has to maintain insurance policies, but it's the board's decision what to put in, what things to put into insurance and how.
Thank you.
Okay. Oh, sorry. One more.
Quick question. My name is Vinnie David Dow. I live on Meadow Lake Drive, right here.
You have the floor.
Okay.
You gotta give the floor back, though, eventually. No, I'm kidding. You have the floor.
Okay. Quick question. For 25 years, I practiced law on Long Island. But there was always another side and another story. And I'm just wondering, how are we going to hear the other side to what we're discussing tonight? To hear what they have to say in regard to questions being asked that we don't have the answers to, but the other side would. And I believe we should have the opportunity to hear that side, that's all.
That's understood. So tonight, I'm used to evening meetings. Today was for me to answer questions and to present the association side, because we have that obligation of transparency, because we want people to understand how your money was spent. I have no problem with the other side presenting their side of it, and we have offered to host a similar meeting at no expense to them, for them to present their side. I didn't want today to end up in a debate between lawyers arguing in front of you as members. It's just gonna, cause more problems. But to the extent, and I can't make, if the owners don't want to talk about it, they have no obligation to. They don't have the same obligations to the association. But if they would like to, they're more than welcome to host a presentation or a Q&A with whoever wants to come to that meeting as well. So if they want to explain themselves or answer questions or present their side, that's fine. They have the same rights to speak as the association does. The lawsuit is over. Yeah.
Thank you.
Okay, so, thank you, David. Okay, so, that's that part of the meeting. Now, in the back, over there on that table, we'll have myself and a couple of board members will be there to discuss, unless somebody has a question about what's going on with the land right now, but I would think most of them will understand. But we can do a Q&A on what's going on in terms of the building, if people have questions. This may be not, let's see if anybody wants to know. But there is an important meeting tonight in Town Hall with our councilmen will be voting on whether they're going to pass, I guess it's a resolution, to do that building. Last night, we were there in force, 95 people, and the court saw that, Lake Ridge is not laying down on this. And tonight, the vote happens. Now, I can't tell you how the vote's gonna go, because I don't have that specific, but we've been in communication with several councilmen who have an opposing view to the mayor. They were here. And the assumption is that they will be voting negatively on that. And what that means is that throws a stop on that lot being considered for building. Now, I'm going to go down there, Ed's going to go down there, and Mary, and I'd like whoever is in that area to come over there, because before tonight, I need to walk into that meeting saying, these people were supposed to be notified and weren't, and you breached the proper protocol, therefore it has to stop immediately. That's the goal. Now, I'm not asking anyone to lie, do not lie. Okay? But if you did receive or did not receive and you thought you should receive, I think it's something like, I'm going to make up a number. I did this morning just before I came here. 43 people should have gotten letters. Okay? And I can demonstrate that to whoever wants to spend the time. But if people got letters on the other side of Massachusetts, that means someone is maybe lying to us that they're including the other side. The north side, which would not be the one going towards 70. That would mean they would surround our Massachusetts entrance. Now, I specifically asked the mayor that question, and he didn't know the answer. So that led me to believe it could be something really wrong here. So I'm going to need your help. So if you know of someone, yes.
Do you mean a letter in the mail?
A letter in the mail or a certified letter in the mail?
It had to be in the mail, because I got an email
No, not email, no. It has to be a letter or certified letter. Yeah, well, I found out last night, speaking to this paralegal, was like a whiz. She said it's a certain percentage has to be certified. I said, really? I thought all of it had to be certified. So, there's a lot of nuances, but I'm gonna be down there, for these questions, because before we go tonight, I have to know who got a letter, who didn't, I'll be knocking on doors later.
I need to.
Okay, David's got some.
I apologize, represented. So, attorney for the unit owners did ask me, and I did say I was gonna say this at the meeting, and I apologize for not saying it earlier. The unit owners did ask me to tell the membership that they had wanted to be here tonight, or today, but they were unable to attend because of a pre-planned prepaid vacation. So it wasn't, the reason they're not here isn't because they didn't want to be here. They're not here because just they had a conflict and couldn't come today. That's part of why we discussed having another meeting at a later date. I told the budget council that I was going to announce that.
Hey, quiet!
So I just wanted to put that out there. Apologies for not saying it earlier.